Hi, my name is Diana Schwartz and I am a Senior Associate at Pukube Pierce Masitelo Attorneys. Today I will be discussing fixed-term employment agreements. A fixed-term employment agreement is a very common type of agreement that one finds frequent use of in the media and entertainment industry. So you may ask, what is a fixed-term employment agreement? This is a contract in which the parties specify the duration of the contract, and it is usually concluded upon a specified date as agreed between the parties, or on the completion of a particular task or project. Unless the parties have agreed that the contract will terminate at an earlier date by notice, agreement, repudiation or breach. Producers or directors in the media industry would probably be employed on fixed-term employment agreements, and they would be employed for the particular production that they're working on, and thereafter, once the production is over, the contract would then be concluded. The law states that an employer cannot employ a person on a fixed-term employment agreement for longer than 3 months unless there is an exception to the situation or there is a justifiable reason to do so. If no such exception or justifiable reason exists, the employer needs to be aware that a fixed-term employment agreement will then become a permanent agreement if the employer continuously renews such an agreement. Can the non-renewal of a fixed-term employment agreement constitute a dismissal? Yes, it can. Our courts have ruled that if an employee had a reasonable expectation of renewal of the fixed-term employment agreement and the employer did not renew or extend the agreement or permanently employ the employee, this can constitute a dismissal. A reasonable expectation of renewal could be a promise made by an employer to an employee to renew or extend the agreement. It is, however, an objective test, and the onus to prove the existence of a reasonable expectation of renewal rests on the employee. The employee must show the existence of facts which in the ordinary course would lead a reasonable person to anticipate a renewal. For example, if the employer had previously in the past renewed the agreement on many occasions. Employers need to be extremely cautious when using these types of agreements, and they must be aware of the relevant labour law provisions that govern these agreements. For any additional advice on this topic, please feel free to contact us.